Hello and welcome to another episode of KNAV podcast series. I'm Kaustubh, and today's discussion is extremely relevant for investors, CFOs, fund managers, and tax professionals dealing with cross-border structures involving India. The Supreme Court recently delivered a landmark ruling on Tiger Global that has significantly reshaped how treaty benefits, commercial substances, GAAR, and indirect transfers will be evaluated going forward. This judgment goes beyond a single structure or jurisdiction. It sets the tone for how intent, substance, and documentation will be scrutinized in cross-border tax plan. To unpack this, I am joined by two senior leaders of KNAV, Uday Ved and Mihir Desai. So Uday and Mihir, welcome to the show. And thank you so much for giving your time from your busy schedule. So just to set the context for our viewers, can you help us, can you briefly walk us through the background of the matter before the Supreme Court and what was under dispute, the key conclusions, and what the court arrived at?
So thank you, Kostu, for having me on the show. This is a very important ruling of the Honorable Supreme Court in case of Tiger Global, as you rightly said. The entire thrust of the issue was the tax exemption, capital gains tax exemption claimed by Tiger Global on the sale of shares, which it had in the Singapore entity to Walmart. So the key contour of the transaction was Tiger Global Mauritius holding shares in Singapore entity claimed benefit of India-Mauritius treaty, stating that such capital gains are not taxable. Essentially, this was a transaction between the two non-resident outside India, and that involves the indirect transfer of shares. There is a very old ruling of Vodafone where indirect transfer issue was being examined and settled at the Supreme Court. Subsequent to that, the law was changed in 2012. It became effective in 2015-16. And now indirect transfers are subject to tax under the domestic law. Here, Tiger Global claimed tax exemption under India-Mauritius double tax avoidance treaty under indirect transfer. Essentially, they had gone to the tax authorities in the very initial stage to obtain the nil ruling under section what is called 197 of the Income Tax Act. They did not get it, and then Tiger Global Mauritius filed an application to the authority for advance ruling. The AAR actually rejected the application, stating that this entire transaction was prima facie undertaken to avoid the tax. So on that prima facie basis, under the general anti-avoidance rules which came into force from 2017, this transaction is taxable. Mind you, the shares were acquired far ahead of the time in 2011. However, the transaction for the transfer of shares took place in 2018, post the GAAR came into the picture. So the advance ruling authority rejected this, saying that its gains are taxable. The taxpayer, the SSE, actually went to the Honorable Delhi High Court to appeal against this ruling by way of filing a writ petition. Interestingly, the Delhi High Court held in favor of the taxpayer, the SSE, stating that no, it was not a tax avoidance transaction, not subject to GAAR. And based on the facts produced before the Delhi High Court, the Delhi High Court ruled the entire thing in the favor of taxpayers, stating that such indirect transfers were not subject to tax, and it was exempt under Article 13(4) of the India-Mauritius tax treaty, and it held in favor of the taxpayer, the SSE. Revenue authorities appealed against this Delhi High Court ruling by way of a special review petition (SLP) to the Honorable Supreme Court. And what we are talking right now is the matter before the Supreme Court. And then Honorable Supreme Court actually agreed with the observations and comments of the advance ruling authority, stating that yes, it looks like that this is a transaction prima facie undertaken to avoid the tax, and the grandfathering benefit should not be applicable. Now there are 2-3 things which came out as a part of that. One was whether the tax residency certificate, which is produced by the taxpayer, which is required under the law to claim the treaty benefit, is it the sufficient and can be a conclusive evidence to avail the treaty benefit? The Supreme Court answered in negative. The second was whether the grandfathering is applicable, and for the indirect transfer, the Honorable Supreme Court held that no, it is not applicable, and it made a fine distinction between grandfathering investments versus grandfathering arrangements undertaken. And said whether the investments were grandfathered, arrangements, if they were prima facie taken to avoid the tax, then they are not subject to the grandfathering benefit. That's the crux of that. And there are various other observations. In fact, interestingly, it's about 152-page judgment. Out of the 19 pages are dedicated to talk on the sovereignty of the tax nations, which we have never found it in the past. But it says that India as a sovereign state has a right to tax and go beyond the tax treaty if the objective of the transaction is to avoid the tax. So these are some of the broad observations, and this could have far-reaching implications for other structures also. We'll talk about it as the show progresses, but that's the crux, stating that such grandfathering is not applicable, and the SAC Tiger Global would be subject to tax, not entitled to the benefit under Article 13.4 of the India-Mauritius Double Tax Avoidance Treaty.
That's a critical foundation there, because ruling is less about one transaction and more about how tax authorities will think going forward. So thank you so much for your views on this. Now, Mihir, I'll come to you. So this is one of the most debated aspects which we have seen. What is the Supreme Court's view on the sufficiency of a tax residency certificate for availing treaty benefits? Can you give some thoughts on that?
Thank you. Sure. Thanks, Kaustubh. Now, the predominant judicial thinking before the Supreme Court ruling, which was based on, circulars which have been issued by the CPDT, as also views, which have been conveyed by the Honorable Supreme Court, is that the TRC, or the tax residency certificate, is a sufficient proof of residency in a particular jurisdiction. Now, what has happened, basis the observation of the Supreme Court, the Supreme Court says that TRC is merely an eligibility requirement and is not a sufficient proof of residency. And there is nothing which prevents the revenue authorities to look behind the TRC to check whether this entire transaction or the arrangement, as we look at it, is it an impermissible arrangement, or is it something which is permissible under law? So, now, because of what the Supreme Court has said, it gives the power to the revenue authorities to go behind the TRC to actually find out whether the arrangement is permissible or impermissible, which is likely to have a lot of implications on any structuring transaction going forward.
Okay. So I have a follow-up question on this, Mihir. So in your views, how does this ruling impact the existing circulars and past judicial precedents that taxpayers have historically relied on?
Correct. So, Kaustubh, there are two circulars, like I mentioned. There is the two critical aspects, which this Supreme Court ruling looks at, and which was something which was relied on by most SSCs when they opted for treaty benefits, was Circular 789 and the Supreme Court ruling of Azadi Bachao. Now, what the Supreme Court says is, the Supreme Court has not really distinguished any of these two documents. What the Supreme Court merely says is that, these two documents, the 789 circular and the Supreme Court ruling of Azadi Bachao, were issued at a time when the legal development of the legal system in this country was absolutely different. There has been a lot of legal development which has happened post 2012, in the form of introduction of GAAR or introduction of indirect transfer. There has been an amendment to the treaty. So, considering all these legal developments, the legal position which stands as on today is not quite similar. It is very different than what it was during the time when these two documents were issued. So, considering the same, the Supreme Court says that one cannot rely on those two documents, considering the changes in the legislature which has happened thereafter. And to that extent, it has said, or it has diverted from the predominant thinking which was there on this subject.
Got it. Thank you so much, Mihir, for giving your detailed views on this matter. So, Uday, I'll come to you now on one of the topics, which is the GAAR. So, GAAR officially came into force in 2017, as we all know, but the court has made some important observations on GAAR even for pre-2017 investments. So, what should investors understand from this now?
For the first time in the ruling, though the GAAR came into force post 2017, of course, when the transaction was undertaken post 2017. So technically, the law applies to any transaction or arrangement undertaken post 1/4/2017. In fact, the Supreme Court mentioned that there is a grandfathering rules which have been prescribed in the Income Tax Act to say that the grandfathering applies only to investments which have been done and not for the arrangement. So if any transaction was undertaken with a view to obtain the tax benefit, that was the key transaction which is under the GAAR main benefit test, and any of the tainted tests, one of the 4 tests which are satisfied, which it was either bona fide, it was a commercial substance, etc., then the GAAR is applicable. So actually, there is for the purpose of applying the GAAR, there is a prescribed procedure under the law. Supreme Court did not go into that. Say it is a prima facie, look, this is avoidance of the tax transaction, and the GAAR should be applicable. And while arriving at it, went through the various technical aspects of the entire transaction, and the fact that the GAAR is applicable, the treaty benefits are not available. I think that was the final conclusion which Supreme Court arrived at it. So we could see those kind of situation where a lot of people have made investment prior to that, which it looked like from the way rules are prescribed, that once the investment were made prior to April 1, 2017, they cannot be questioned on the GAAR. And the Honorable Supreme Court said no, it can be questioned because it looks like, and the taxpayer also argued that I bought the shares in 2011, I sold it in 2018. They said the length of the period is not relevant, which was actually the case when the Vodafone transaction happened that 15 years back, where one of the key criteria was that the length of the entity was an important factor, not necessarily a conclusive factor. It got implemented in the GAAR provisions from section 95 to 102. And the Supreme Court said the fact that it was an old entity and you made an investment is not relevant if the predominant purpose was to obtain the tax benefit.
Correct. So, can you say effectively this judgment narrows the comfort zone that many investors assume existed for older investments?
That's true, because that's a lot of investments which have happened in the normal business transactions, a lot of investments which have happened by the funds, the foreign portfolio investors or FIIs, and those are the kind of questions which will come up. It can also impact the other treaties and other structures, because conceptually, although the ruling is under India-Mauritius Treaty, the predominant aspect is the tax avoidance, anti-avoidance provision under GAAR. So one would have to see how it evolves over time. But yes, the investors may be concerned with that.
Thank you so much, Uday, for your views on this. So Mihir, the next question comes to you. The term commercial substance appears repeatedly in the discussions around this ruling. So what does commercial substance really mean in the practical terms, and why will it matter so much going forward?
Yeah, thanks, Kaustubh. I think I'll connect it again with the first answer on tax residency certificate. So what used to happen, like I mentioned, that earlier when it came to these transactions, the TRC was always considered to be a sufficient proof of evidence, which may no longer be the case considering the observations of the Supreme Court. So now the Supreme Court will go behind the TRC to actually find out, if this entity is operating, when it is operating, say, in a jurisdiction like Mauritius or Singapore or Cyprus, whether it actually has a substance in that entity. And by evaluating of substance, they will go behind the real head and brain, whether the head and brain who's operating the entity, the board of directors, are the decisions being made in Mauritius? Or is it a case where Mauritius entity is merely a puppet and it is somewhere else, its holding company, which is actually making the decision? They might also evaluate cases of beneficial ownership, from where has the money come into the country? Is it the Mauritian entity who has pumped in the money? Or is it the case that the Mauritian entity has been merely used as a conduit for the purpose of parking investment? Why is Mauritius or Singapore selected as a jurisdiction? Are there any other reasons apart from tax which have been considered for selecting that as a particular jurisdictions? Are all some of the questions in the days to come which may come up before the tax office, when it comes to getting these treaty benefits? Because commercial substance, as you rightly said, is a term which is going to gain significant importance in the days to come.
So this isn't about just ticking the boxes. It's about telling a credible business story.
Correct. We will have to justify. We will have to justify why the investment is being made from Mauritius. What is the purpose of the investment? We will have to justify that, the entire control rests with the Mauritian entity. There is no one else controlling it. So only after you tick all the relevant boxes, and we don't really know what those boxes are going to be. But once you tick all those relevant boxes, only then possibly the department might take a view that you do satisfy commercial substance.
Thank you so much for your detailed understanding on this. Uday, I'll come to you. So coming to Article 13 and indirect transfers, what is the Supreme Court's view on treaty eligibility in such cases? Can you give your thoughts on this?
So I think the key part is the GAAR and the indirect transfer, which Supreme Court has really commented on, that was the key aspect of the transaction. But various important observations and comments which have been made, which are possibly in variance with what was held in the past. And you know that the law of the Supreme Court is the law of the land. So although it may be in the context of a particular transaction, all the observations, and particularly on GAAR, there are few rulings on GAAR, but they are at either a tribunal level or maybe at the High Court level. Now, this is the first ruling as given by Supreme Court. That's a law of the land. So all the observations on tax avoidance would really be now becoming relevant in terms of, as I mentioned before, the investment versus arrangement, whether what are the main purpose, was this done only for for the purpose of tax treaty benefit, or there was something else. In fact, there are a lot of FIIs, FPIs who have made investment. Those questions will come up also, right? There are a lot of pooling vehicles in the context of at least the funds and FIIs which have been done, and you have various investors come in. They want to invest in a particular entity, and then the investment was done in India. So why Mauritius? Why not other entity? Was there any substance? All these questions can now be questioned by the tax department. That does not mean that there is a GAAR automatically. It will be based on the specific facts. But this could reopen a lot of those past transactions which have already been been implemented, and that's why there is an uncertainty around this part. Always there has been a policy decision and then the administration, which is sometimes lacking, right? And how will the tax department actually interpret this, administer this ruling, would be of a lot of significance going forward.
Okay, so which means this is particularly relevant for funds and holding companies structure.
Yes, but it would be relevant for all holding company structures, certainly, and you would find almost all the investment routed through Mauritius, Singapore may then technically be questioned. Assuming it was prior to 2000, after 2017, anyway, the law has been changed. Now, the capital gains on the sale of shares are fully taxable at a normal rate. It was in between 50% tax rate till 2019, but post 2019, the normal tax of now 12.5% plus surcharge is applicable on long-term gains. But interestingly, when the Mauritius Treaty was amended, it is amended in the context of shares. FPIs and other funds may be holding other than shares, derivative contracts. Those are technically still eligible for treaty benefits under India, Mauritius, and maybe under the few other treaties like Singapore, Cyprus, etc. Even those could be questioned, although the treaty, there is no change in the treaty. So the derivative contracts which are not shares are exempt under India, Mauritius Treaty. Even those could be questioned on the basis of the commercial substance, as Mihir just explained. Right? So all those things may be also a question, and if that happens, issue which was there many years back and it got settled in Azadi Bachao, which was Supreme Court, could be reopened. One would see how the actual implementation goes. But the FIIs and FPIs may be concerned because of that.
Thank you so much for your views on this. Mihir, my next question is for you. So, an important question which many investors are asking today, will this ruling only impact Mauritius-based structures, or it could extend to other tax treaties as well?
I think this was something which was covered by Uday in the introductory part, that quite a lot of these observations regarding TRC or GAAR, or not granting grandfathering benefits to pre-2017 investments, requiring a commercial substance. The principles will apply to treaties like, say, Singapore also, or Mauritius, or Cyprus. So on principles, the observations of the Supreme Court should not be restricted only to Mauritius and may even be extended to the other treaties.
But I would just add here one more thing, other aspect, that it's not only the context of the specific treaties that Mir just mentioned, Mauritius, Singapore, Cyprus, etc. But the entire international tax structures could theoretically be questioned. As an example, when an Indian company has paid royalty to a foreign entity, whether the treaty benefit should be applicable based on the tax avoidance or otherwise. So the treaty benefit of 20% tax under the domestic law for royalty and fees for technical services versus say 15 or 10 in few treaties, right? Whether that benefit may be applicable or not will be a question. Second, a lot of remittances today go outside the country in the form of chartered accountant certificate. So the CA certifies that a particular tax is levied. That's what has been prescribed for the last so many years. Now a chartered accountant also, while issuing TR the certificate under 15 CACB, would possibly will be advised to take more precautions, right, and do a little bit more diligence rather than straight away give the treaty benefit. So it will also add to that kind of a question again for the, and this could be a very grassroots level remittance that you are making. Whether obvious, you don't question the tax residency certificate, which is fine. But as Mir said, the Supreme Court observation is TRC gives you an eligibility. It's not a sufficient condition. So just because the taxpayer or SSC has a TRC does not mean that you will grant a tax benefit while issuing the CA certificate. So even the the obligation of the chartered accountant to that extent, one would, in my view, it will go up. So this could have a far-reaching implications.
Thank you, Uday and Mihir, for those incredibly insightful perspectives on this entire matter. What's clear from this ruling is that cross-border tax planning has entered into an era where one where intent, substance, and consistency matter more than ever. For investors and businesses, this is the moment to reassess the structures, strengthen governance, and proactively manage risk. So, do you have any final closing comments on this entire matter before we sign off?
Interestingly, if you look at the ruling, the Honorable Supreme Court has just agreed with the advance ruling authority, stating that this transaction was undertaken prima facie for avoidance of tax. Okay, so it has just agreed on that without the specific facts of the case in detail. What may happen now is that the tax officer, assessing officer, will actually, based on the facts gathered, do an actual assessment of income in this particular case. And then finally, the tax liability may be determined or not determined. That's how I look at it. So although this is a fact-specific case for Tiger Global, the important part is the observations and comments of Honorable Supreme Court in the context of entire interpretation of tax treaties. And so those observations are very relevant, and that may actually change the way our entire international tax treaties, international tax principles will be interpreted going forward in the Indian context.
Okay, thank you so much, Uday and Mihir, for giving time from your busy schedule to throw some light and giving your valuable perspectives on this entire matter. To our listeners, thank you so much for tuning in. If you found this episode interesting and informational, please do follow KNAV Podcast for more expert-led conversations. Until then, stay informed, stay applied.